video of the three branches of government and probably the final video for the semester. So I'm glad you're probably really happy about that. Um, what we're going to talk about here to finish up with the three branches is we're going to get into how the Supreme Court works. Okay, so I'm going to outline for you kind of the procedures. Now, I'm not going to get into a lot of detail. There's a whole lot more we could get into with this whole thing, but just to give you the basics of how the Supreme Court operates and works, we're just going to kind of run through that here. Okay, so how the Supreme Court actually operates is basically there's two ways that a case can come to the Supreme Court, which I'll kind of show you a slide on that here in a little bit. But one of the ways it can come to the Supreme Court is by what's called a writ of certiorari. And what that means is Latin, and it just simply means to be made certain. And every year, about 4,000 of these arrive to the Supreme Court. Now, how they get there is lower court decisions. So you have a court case that, let's say, happens here in Garden City, and it's dealing with a murder case, let's say, and the person gets found guilty. Well, he can appeal or she can appeal their case to the state Supreme Court or to the Court of Appeals in Kansas. And then from there, it can go to the Kansas Supreme Court. And again, from there, it can go to the U.S. Court of Appeals, and then it can work its way up to the U.S. Supreme Court. Now, it doesn't just simply mean because you lose the case, you get to appeal it. The only way any court's going to take a case is if they think that there is a possibility that there could be something wrong with the case, if it wasn't tried correctly, if there was an error made, if there was a right that wasn't being given to the defendant, any of those kinds of things. So what happens here is a lower court decision is made. A attorney for the representative, the client who is lost the case, will create this writ of certiorari. And basically what's in it is a copy of the lower court's opinion in order for the upper court judges to review. It's a statement of legal questions about the case as to why they think that the Supreme Court should listen to the case, hear the case, and rule on it. And then statements by the lawyer stating why the case needs to be overturned. Of those 4,000, only about 150 or so are picked by the 9 justices. Each justice has about 3 or 4 law clerks who work for them, whose job it is to go through those writ of certiorari. So the justices themselves don't go through them. They will go through, these law clerks will, and they will basically write out summaries of each of these certiораries, which they will give the justices then to study over, and then the justices will get together and do what's called a rule of 4 vote. What the rule of 4 vote basically does is it requires 4 of the 9 justices to agree to hear a case. If 4 of the 9 justices vote to agree to hear a court case, then it will be brought up to the Supreme Court then. Factors that the justices look at to determine whether they're going to hear a case is this case decided differently from a similar case in a previous ruling? So if it is, for example, if there was a case that was very similar to this one, and in that case the defendant was found not guilty, but in this case they were found guilty, the justices are going to want to know why. So that's one reason why they may take a look at this case then if it was ruled differently from some other one. Also, they're going to look and see, was the lower court decision incorrect? Sometimes judges make mistakes. Sometimes errors are made in cases. Everyone's human. So the Supreme Court will take a look very closely at how the court was ruling on the case, and they'll see if there was any errors made or discretions made or anything like that. Finally, they want to look at the constitutional rights of each defendant who was being charged for a crime or for whatever the case was dealing with. And if their constitutional rights was denied to them, then they're going to want to take this case to rule on it then. The petitioner is the person who wants the court to make a change of the ruling. So the petitioner is the person who lost in the previous case down in the lower courts. They are the ones who are writing the certiorari and requesting the court to hear the case. A defendant, respondent, is the person who wants to keep the court ruling as is, no changes to be made in it. And we'll get a little bit more into that back in class. Okay, here again is a slide that kind of shows you how the process is done. Here is a federal district court where a case could be heard. It could also be just a district court in a state. The case is filed. From there, it would go to an appeals court, whether it's a state appeals court or the federal, and the case would go there. Now, if you notice here that once a case is done here, then the court case can come to the Supreme Court. Cases is appealed to the Supreme Court either by allowing the lower court ruling to stand, or the Supreme Court can also send the case back to the lower court to reconsider. So the Supreme Court has three choices here when a case comes to it. It can simply say, no, we agree with what the lower court has said, and in which case they won't hear the case, and the case is pretty much done. Secondly, they can go ahead and hear the case, which is the bottom one here. They will take the case, listen to it, and rule on it. The third thing the court can do is they can tell the lower courts, you take the case back and you retry it all over again with the following discretions put into it. So there's three actual things that the Supreme Court can do. All right, let's say the court case takes the case. Well, what do? The Supreme Court is only open to sessions on Monday, Tuesdays, and Wednesdays. Thursdays and Fridays, they don't hold court. They basically are either writing their opinions or they're doing research at that time. This is the only time the Supreme Court actually listens to a case. What happens is the case opens up, the lawyers come in, it's in this huge massive building called the Supreme Court in Washington, D.C. is where it's located at. You go into this massive building and then you go into the courtroom, which is actually fairly small. Up at the very front, you have 9 justice seats up on a huge bench. That's where the justices sit. Then from there, you have 2 huge podiums. That's where the 2 attorneys will stand when they present their arguments. There are no witnesses. There are no bringing in of juries or anything like that. The public does get to come in and sit and listen, but only for about 15 minutes. They only have a small amount of chairs that the public can come in and listen to a case being presented. You don't get to talk. You don't do anything while that time's going on. The lawyers who come in to present the case, they come in, the one lawyer would get up first. They have a maximum of 30 minutes to talk unless the Supreme Court has granted extension to that. Otherwise, it's 30 minutes. During that period of time, the lawyers can be stopped by the Supreme Court justices and asked questions. That eats into their time. The purpose of why the lawyers are up there talking is to actually provoke questions from the justices, though, because they want to get those justices' interest in the case. The justices don't have to listen. They already have all the information from the case. They're just simply allowing the lawyers to give more presentation or more arguments. If the lawyers are good, they will get the justices to listen to them. If the lawyers are not so good, the justices may not necessarily be listening too much to what they have to say. You have 30 minutes to talk. Once that 30 minutes is up, a light will come on, and basically you have to sit down as a lawyer. Then the other lawyer gets up, presents his case for 30 minutes. The green light will be on. When the red light flashes, that lawyer sits down, and then they're done. After that, each lawyer will bring in and submit what's called a brief. Now, a brief is a legal document created by the lawyers to present their case. It's usually about 50 pages, which is kind of ironic because you don't think of the word brief being 50 pages long, but in legal terms, that is actually a very small document. Finally, the last thing that happens in a court case is once all that is done, all the presentations given, all the information's done, the justices have to make a decision. Once the court finishes, the justices then will sit down. Now, they don't do this in the very same day. It could take them 2 days, 3 days, 4 days, 5 days. Usually it's months. So usually the first court here is heard for the justices. They start in the first Monday in October, and they will rule up to about usually sometime around May or July, and then they're done. Then they will, in June, they will usually present their opinions. So it's not like they're going to hear a case and that same day they're going to give out their ruling. Usually it's several weeks goes by so that it gives the justices time to sit down, research, read, go over all kinds of stuff. These are the main types of opinions that the justices will give. One is called a majority opinion. Pretty obvious what that means. It means that the court is basically given the opinion of the court that announces the decision, and it's made by the majority base of the court. Remember, there are 9 justices. So if 5 or more favor a certain side of the opinion, then one of those 5 would write a majority opinion then. The justices who don't agree with the majority, they also get to write an opinion. That is called a dissenting opinion. Dissenting opinions are written by those justices who do not agree with the court's majority. This is also vitally important. Okay, and again, just like that idea of majority rule, minority rights, this is important in Supreme Court because later on, 5 years, 10 years down the road, when another case comes up very similar to this case, what justices will do is they will go back and reread the opinions of this case. They will read the majority and the minority. And there's been many times which our Supreme Court has overturned a court case over past years, and they will go along with the dissenting opinion now. So it's not that the dissenting opinion is wrong. It's just that in this case, the majority of the court went one way instead of the other. And that could be because of personal bias. It could be because of how they interpret the law. Lots of factors. So it's not a right and wrong thing. It's basically what the viewpoint of the justices is at the time. Now, the other one over here, this is concurring. Concurring are sometimes authorized by justices to add something. In other words, the majority, let's say the 5 justices that were the majority here, let's say 2 of the justices, they were part of this majority, but they disagree as to why they were in favor of the ruling. They may have a different opinion. That's what a concurring opinion is. It's still part of the majority, but it's another part of it where they can make up their opinion as to why they went along with the majority. Maybe they didn't totally agree with what the majority was doing, but they agreed enough to go along with it. So again, these are very important opinions to be writing by the justices, and they're very detailed and they're very well written. Finally, then, what we call a precedent. This is what we name as these majority opinions once they have been created by the Supreme Court. They're not laws, but they are what's known as precedents, which means examples of followed by similar cases as they arise in the lower courts. For example, okay, abortion is not a law in this country that's legal. Roe versus Wade was the Supreme Court case in which the majority of the Supreme Court justices ruled that an abortion is a woman's right under the 14th Amendment and the 9th Amendment. Today, this is still the precedent of the ruling back in 1973, that women still have the right to proceed with an abortion because it's their body to do as they choose, and that the ruling has come down that the fetus is not a live human being until it reaches the term of viability. So that is the new precedent. Now, it's not a law, but it is a precedent. Okay, that explains the whole Supreme Court process. Hopefully it was not too hard and not too difficult to follow along with, and you are done with all of your presentations now.